Hey, welcome. I'm so glad you're here with me today. Chalet in the house. Chalet in the house. Excellent to see you again. I hope you had a good weekend. And we've got a lot to talk about today. I should change this. There we go. Are you ready to ramble in the corner? And are you ready to ramble? I hope so, because we're going to be talking about Delphi today. And there have been quite a few court filings. I went to get the document by the prosecution that we're going to talk about today. And as I went to find that, hey, good morning, Robert, True Crime Cult in the house, and Andy in the house. Woohoo! The shade, look at that. Make my hand looks blue. My arm looks blue. It's weird. It's just the lighting. Don't worry about it. And Lemoyne in the house. All right, welcome. So when I went to get the PDF of this document that we're going to go over, I ended up downloading like 5 or 6 documents. Oh my goodness, there was like so much has happened in the past couple of days, but we're just going to go over this one, and it's called Motion in Limine. And it's filed by the prosecution. And so he's asking the court to make an official trial. Because, you get all these like hearings before the court. Before the trial, you get all these different hearings about this and about that. Well, this is like asking the court that before the trial, you make an actual trial decision, right? And so he's asking that some things not be allowed to be talked about. And so we will be going over that. But some of the other things that have happened was, last week, the defense filed a motion to compel. And then, so now the prosecution has filed their response. And then the defense has filed a response to the prosecution's response. And the defense has filed a 4th motion for a Franks hearing, because the 1st, the 2nd, and the 3rd, nothing has happened yet. So now they have filed a 4th one saying everything that we filed before is hereby included, and here's some more information. And that's like a whole show in and of itself. True Crime Cult says we're doing it tomorrow night because it's going to be on the Karen Reed case, the live. So are you talking about a live with me and AR Hayes? Are you talking about that live? Let's see, it's the morning for you right now. Yes. So you don't want to do it your tonight. You want to do it tomorrow night. Your your Wednesday night. So everybody, while I'm getting this information from Robert, so I was watching his live this morning. I think, gosh, was that just this morning? Or was it yesterday? I don't know. Either last night or this morning. I was watching his live, and he asked me to come up on panel and talk, so I did. And then AR Hayes from A Convict's Thoughts also joined the chat, and he invited him up. So it was the 3 of us on panel, and it was really good. And so we decided that we wanted to do another live with the 3 of us together. So he's free on Wednesday, okay, which is my Thursday morning. Chalet, can you tell me what time is it for you right now, East Coast time? And Robert, are you on East Coast time? So I need to know, Chalet, or Robert, I need to know what is East Coast time right now for you guys. We'll get this out of the way, and then we'll jump into this document. Oh my gosh, it's crazy. It's 10. Okay. And it's 9 p.m. for me. So you guys are an hour ahead. And you're in Central. Okay. Because at 10 a.m., which would be your 11 p.m., Eastern time, 11 p.m. So actually, if you're on Central, then we're just AM, PM away from each other. Yeah. So I have tutoring at my 10 a.m., which means I should probably like get off at 9:30 a.m., which would be your 9:30 p.m. Right? I mean, I would have to be finished at 9:30 p.m. You guys want to start at 9 p.m. on Wednesday? Yeah, Central is 1 hour earlier than Eastern. And since Eastern is 1 hour ahead, that means that Central is the same time as me, but switch AM, PM. Okay, so Robert, we can talk about this after. So let's get into this because we don't want to make people wait for the topic. All right, let me share my screen. Or share. Yeah, okay. This one. Motion in limine. All right. I'm going to share this window. Okay. And we're going to make it a little bit bigger by going like this. It's a little bit bigger for you. Yeah, exactly. Until we change time again. Chalet, you're going to join us in chat. Yeah, it was nice to see Andy. Andy got to see the video when I was on his show. That was nice to see you there, Andy. 12 hours difference. Yeah, because you're also in Central, right, Lemoyne? Yeah, right now is 9 p.m. for me. But it's 9 p.m. on Tuesday night. And you guys are in Tuesday morning. All right. Yeah, we'll sort that out. So let's go over this document. Oh my goodness. All right, you guys ready? So now comes the state of Indiana by prosecuting attorney Nicholas C. McLellan and respectfully requests that the court enter an order requiring the defendant or his counsels to refrain from mentioning. So don't talk about this, right? In the presence of the jury during, that's called voir dire, the opening argument, the presentation of evidence, and the closing argument. So that's pretty much during jury selection and the whole trial. Okay. Any and all references to the following, either directly or indirectly. You can't open your mouth and say anything about what he's going to list. All right. Now, if you want to know the real like legal perspective, because I'm not a lawyer. So if you want that real legal thing, side of things, I highly recommend Defense Diaries podcast. You go find them. They're really good. They're both lawyers. It's a husband and wife team. They're both lawyers. They're awesome. I'm not a lawyer, so I will say that these first couple of like 1, 2, 3, they were saying this is kind of normal in a way but we get into the juicy stuff. So number 1, any comments about counsel for the state, that's Nick, that constitutes a personal attack on the attorney for the state, Nick, or comments on the role of the state's attorney. Okay, so that's ethical behavior by a lawyer. All right. Number 2, any comment which constitutes the personal opinion of defense counsel about any evidence, witness, outcome, or penalty. For instance, they cite, I'm not going to go over the cases that they cite, but he cites some cases. For instance, defense counsel cannot vouch for the truthfulness or competency of any of the state's witnesses, including police officers or any of his own witnesses. Now, this part's really interesting because it's like, that's something that the defense would put, because normally the defense is the one filing a motion in limine like this. And so, are you, Nick, are you expecting the defense to vouch for the truthfulness or competency of any of your witnesses, including those police officers or any of his own witnesses? All right. Any innuendo or inference that is not supported by admissible evidence. Now, I think this part here, he's kind of setting things up where he's going to try and get as much evidence as possible that they want to have admitted, not admitted. And then once it's not admitted, it becomes, it would fall under this, right? Because it's not supported by admissible evidence. So I think he's kind of, setting the stage there for that. So the attorney cannot assert unsubstantiated allegations on collateral matters. So Nick, we saw a taste of this in that hearing. Well, we didn't see it visually. There were no cameras, but we did have the court transcript and a lot of people that were witnesses that then came out of the court hearing and told us what happened, right? And Nick so many times was like trying to say, but that's not relevant. That's not about Richard Allen. Richard Allen's the one that's on trial. All this other stuff doesn't matter, right? He kept trying to. So we see where he's going with this. The attorney may not comment or allude to inadmissible evidence during trial. And I guarantee he's going to try and get as much as possible that the defense wants to bring as inadmissible. You have a question on the gag order? Is there a gag order in this case in Delphi? Yes, there is a gag order. Because Nick was trying to say that the defense had violated the gag order. So there is a gag order. I don't know in detail because that happened 2022, like in November or December, right after Richard Allen was arrested. Well, I mean, like within 2 to 3 months of him being arrested. No, he has a question on any kind of gag order. Oh, like this would be a gag order. Got it. Yeah, it's kind of like a gag order is what he's asking. Yeah. And so he's going to try and get everything inadmissible. All right. Number 4, any attempt to indoctrinate the jury during voir dire by exposing the jury to substantive issue in the case. So basically this is saying, so voir dire, in case you don't know, that's during the jury selection. And you're asking the jurors, well, I'll just give a personal experience. I got called to jury duty, and it was a case about a farmer that had like boll weevils in his grain, whatever his crop was, and in the silo or whatever. And he had insurance, but the insurance company didn't want to pay. So I think he was suing the company, the insurance company, to pay, right? And so the lawyers kept asking things like, have you ever read a John Grisham book? And I'm like, no. Have you ever seen a John Grisham movie? I'm like, no. I actually accidentally had seen one or two, but I didn't know that they were based on John Grisham novels, right? Like The Firm or something. Because those books always put the big bad guys, it's the little guy against the big bad guys. And so they didn't want jurors that had read John Grisham books. Okay. So that jury selection, both the defense and the prosecution are asking potential jurors questions that help them eliminate or choose the people as jurors. The Rainmaker, I certainly hadn't read any of the books. I accidentally had seen one or two movies at that point, but I didn't. So I answered honestly because I didn't movies. So that's what here that's the voir dire. And so what he's saying is like, you can't have any specific examples that substantive issue in the case. You can't give any details of the case but you have to have questions that do not prejudice the jury, basically. Because if you ask a question about something too specific, then it tips off the jury, right? And it could prejudice them. So that one there is actually a little bit normal. Okay. Any attempt during voir dire to have the jury prejudge the credibility of a witness. Any hypothetical question that includes facts that are not in evidence or questions that are not helpful in violation of Rule 705. So what will be in evidence or not in evidence? They're going to fight to get anything Odinism related out of not to be part of evidence. The Pelican Brief, The Firm. I think I had seen The Firm. Maybe I'd seen the Pelican Brief at that time. I'm not sure if I've seen them all by now, but anyway. Exactly. Those are John Grisham movies, or books, movies made from books. So number 7. Okay. We're getting good here. Any attempt to introduce evidence of third-party motive that is not relevant and or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury in violation of Rule 401. Now, he's going to cite Rule 401 again and again and again. You could remember the Bullock film, but you had to look it up. It was a good one. So like when he says confusion of the issues, I guarantee you he is talking about the only issue is Richard Allen is guilty. So if you want to bring up anything that would confuse the fact that Richard Allen is guilty, such as something that would be reasonable doubt, you're not, he doesn't want anyone to say anything that would confuse the issue or the potential to mislead the jury. So anything, basically what he's saying, honestly, anything that would lead the jury to believe that Richard Allen is innocent in his mind, which that's what defense is. So I'm thinking, and I don't know which constitutional amendment it is, but there's somewhere in the Constitution that you have a right to a defense. So I think this would be violating his right to a defense because it gets, oh my gosh. Let's keep going. Before any such evidence may be permitted, the defense must show some connection between the third party and the crime. Sounds fair enough. Further, it must be a direct connection based on admissible evidence and not founded in hearsay. So Elvis Field saying that he spit on the girls, well, that's just hearsay, right? Because that's what Todd Click is saying that he said. It's not an actual, it's not Elvis Field saying it as the evidence. And I guarantee you they're gonna, well, he does. He mentions Todd Click later, saying anything from Todd Click not admissible. Right? So it sounds good. Before any such evidence may be permitted, the defense must show some connection between the third party and the crime. Reasonable. But further, it must be a direct connection based on admissible evidence, which, if Nick has his way, is zero. So therefore, there cannot be a connection because there's no admissible evidence if he gets his way. Oh, not founded in hearsay, speculation, rumors, conjecture, or theory. The state requests such order in limine to include but not be limited to the following. Get ready, buckle up. A, Odinism. B, cult or ritualistic killing. C, Brad Holder. D, Patrick Westphal. E, Johnny Messer. F, Elvis Fields. G, Ned Smith. I don't even recognize that name. H, Rod Abrams. I, Keegan Klein. J, Jerry Klein, which I think the father was Tony Klein, right? I don't know if that's a misprint or if there is a Jerry Klein. And K, Ron Logan. Second Amendment right to self-defense. 6 is the defense in court. Okay, his Sixth Amendment rights. This is like a total violation of his Sixth Amendment right. Okay, number 8. Yeah, so you know he's like wanting to eliminate any mention of all of this or those people. And Keegan Klein and Ron Logan, I don't know that there's like the whole Odinist thing connecting with them, but they were previous suspects. So it's like the prosecution wants the jury to believe that in 6 years of investigation, Richard Allen was the only person that they ever looked. I mean, all roads pointed to Richard Allen. They didn't, nobody else was on their radar ever at any time. It's only Richard Allen. 8, any reference to an investigation conducted by Todd Click, along with any reports or investigative materials from Todd Click that is not relevant or is used for the purpose of confusing the issues. Remember, I told you that? Anytime you see confusing the issues, that means anything that takes away from somebody believing that Richard Allen is guilty. Because if you try to raise any reasonable doubt, you're confusing the issue or has the potential to mislead the jury in violation of 401. And then he just goes over again and again the use of 401. The burden is on the opponent to show why it's relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. And then evidence may be excluded if it confuses the issues. All right. So I'm not going to keep reading that because he keeps repeating that as we go on. Number 9, any reference to geofencing and or any testimony from Kevin Horan about geofencing or the findings from any geofence search that is not relevant or is for the purpose of confusing the issues, or has the potential to mislead the jury in violation of Rule 401, blah, blah, blah. Number 10, any reference to any prior bad acts or acts of any witnesses that plan to testify at the trial that is not relevant to what the defendant is on trial for, that he's on trial for the murders, right? So how is anything that's about the investigation of the murder not about the murders? What he means is that anything that does not say Richard Allen is guilty, so not relevant to the defendant being guilty, is what he means. That so any prior bad acts or acts of any witnesses that plan to testify at the trial, that is not relevant to what the defendant is on trial for. That is not an act that is an exception to IRE. That's like Indiana rules, 404B. And that is not both relevant under 401 and tend to negate the guilt of the defendant. Anything that tends to negate the guilt of the defendant. It's right there. It's what I've been telling you. Sixth Amendment. So anything that would lean the jury towards believing Richard Allen is innocent, or anything that raises reasonable doubt, he wants out. It's right there. Anything that would tend to negate the guilt of the defendant. How can, and the worst thing is that Gull will probably say, oh, okay, no hearing needed. Yes, rubber stamp. Does Gull have the guts to not buy this? I don't know. We'll find out. 11. There's more. Any reference to how the files were labeled that were handed over to the defense as part of the information and discovery provided to defense counsel by the state that are not relevant or that would tend to cause confusion of the issues or has the potential to mislead the jury in violation of Rule 401 with the blah, blah. So, you see, he's kind of showing his hand a little bit here too. So does that mean that there were mislabeled files? Of course there were. And, remember they just jumbled everything up. They know, number one, they know that they tried to hide stuff. They know the defense is onto them that they tried to hide stuff and isn't afraid to bring it out. And I think in some of these other filings, all these responses, I was telling you, compel, response. I think they do get into that, how they tried to hide things. And he doesn't want that coming out, that they tried to hide things. Oh, I don't want to be embarrassed. I don't want to be caught with my hand in the cookie jar. Number 12, any reference to any PowerPoints provided by the state as executive briefs involving any person or persons that were investigated by law enforcement as part of the 6-year investigation into the murder of Abigail Williams and Liberty German. Wait a minute. Sidebar. Didn't Nick jump all over Baldwin and Rosie for including the names of the girls. And I can tell you in every filing since, they'll put AW and LG. They don't write their names. And here he is putting the names. Whatever. That are not relevant or would tend to cause confusion of the issues or has the potential to mislead the jury. So what PowerPoints is he afraid of coming out? Any PowerPoints involving any person or persons that were investigated in the entire 6 years of the investigation. What's the point of having discovery of the state having to hand everything over to the defense if it's not for the defense to look at it and use it? So, and then wherefore the state of Indiana, by prosecuting attorney Nicholas C. McClellan, respectfully requests this court to grant the following relief. So officially, this is what he's asking for. A, order the defendant through his counsel and witnesses to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to any of the above matters without first obtaining permission of the court outside the presence and hearing of the jury. And B, to further order said persons to make no reference to the fact that this motion has been filed and granted, and all other relief just and proper in the premises. Does that mean he doesn't want us to, that he didn't want this to be public? This is a little late for that, if that's what, I'm not sure. But yeah, so Andy says, okay, I get that some things may be prejudicial or sway thought, except the truth will be able to withstand any contention. Yeah, should. It should be. You know, the truth will set you free. But they haven't been telling the truth. And they know they haven't been telling the truth. And these other documents that I also downloaded are calling them out on a lot of, lie, 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 lie. So wouldn't this just be a dream of any prosecutor? Nothing that might cause reasonable doubt is allowed. This is going to be a very interesting. We're 2 weeks away now. The 13th, May 13th. I don't think that's opening statements. I think that's jury selection. I think that's officially like the beginning of the trial. I think. So May 13th, 2 weeks. And we're still going over all of this stuff. And I mean, is she ever going to do anything about the Franks hearing? Because I don't think you're supposed to be able to rule on that. She rules a lot of things about hearing. In the case of the Franks, you have to have a hearing. Hey, Rex Stardust, welcome. We just finished reading everything. Pre-selection is the 13th, right? Yeah, that's what I thought. So the voir dire is the beginning of trial. So, because that's when they're in the courtroom. But yeah, oh my goodness. So Rex, have you seen this motion? The motion in limine that Nick had just filed? I mean, I just couldn't believe it. We just went through the whole thing, but basically he's saying anything that causes reasonable doubt, anything that calls out the prosecution or the state or the investigation, it can't talk about it. The truth will out, Andy says. Any cover-up, lie, or suppression only gives more light as to why the suppression or lie. Exactly. Like geofencing. Oh, no. Because wouldn't the geofencing be included in like all the investigation stuff? Well, one was kind of more specific to witnesses, but I mean, he's specifically calling out the geofencing. So if it's that important to not have it, then that means it's important. Good morning, Stardust, Chalet says. And coffee, coffee, coffee for dust, Andy says. So what do you guys think? What do you guys think? Does anybody want to, you guys, we're a tight group here right now. You guys want to come up? A couple of people want to come up? I mean, Rex or True Crime, True Crime Cult, or even Lemoyne or Chalet or Andy, if you guys want to come up and share what you think. I'll put the link in if you guys want to say what you think. Meanwhile, I'm just going to make sure that I've got the live chat replay set here. Good morning. Good morning. Let's see, studio. Content, live, customization, live chat replay is on. Excellent. And while I'm here, I will put this in the true crime playlist. Done. All righty. So you guys, anybody want to come up and share what you think? You'll pass. Rex is passing, trying to get some stuff done while you listen. All right. I don't know what else there is to say, unless you want me to go over the one of the other the fourth Frank's motion that was just filed, because I think what I'd like to do is go over the motion to compel and then the response and then of the prosecution and then the response of the defense, kind of like all together. And then that way you kind of have a cohesiveness for it. But also today, let me see here, 29th, prosecution's answer. This one. Okay. Yeah, so I'll remove this one. What about that New York DA? Oh, Lemoyne says you're going to wait until after the verdict before you voice your opinion. That's fine. That's fine. Okay, so I got to stop that one. Oh, wait. Just a second. Why am I only seeing one? Ah, okay, is that? There we go. Okay, fourth Frank's motion. All right. Would Alvin Bragg case, was that the crime? Do I ever go over the state's response? No, not yet. That's what I was just saying, that because the state responded and then the defense responded to their response. I have both of those. I downloaded everything. What do you guys want to do? You guys want to go over it? I can open that instead. We could go over but okay, so that was done it was done a couple of days ago. This one was like today or yesterday. I'm in Cambodia. I guess you're yesterday. Any of you guys would have been tackled to the ground. Alvin Bragg, you want me to look that up real quick? Manhattan District Attorney. Alvin Bragg warned about confusing the Trump jurors. Oh, okay. Okay. From that, we're going to stay on Delphi. Letitia James case. You haven't heard the defense's response. Okay, did you hear the prosecution's response? Should we do the prosecution? Or that's what you're saying you haven't heard? Okay. All right. Let me close these so that they're not mixed up. Defense response to state's response. Open. Okay, it's open. Let me come over here. So I need to remove this one. Share the screen. Don't know what her name is, but it's in the algorithm. It'll show right up what kind of pieces of it. All right, here we go. We'll do it. So the defense filed a motion to compel, and then the prosecution filed their response, and now the defense is replying to that response. Sure, we have time. Yeah, I'm good. It's nighttime for me. It's 9:42 p.m. I have nothing else happening. So I'm good. So the official name of this is called the accused's reply to the state's response to motion to compel and sanctions and request for the state of Indiana to be further sanctioned for providing false information in its response. All righty. Comes now the accused, Richard Allen, by and through counsel, and files the following reply to the state's response to defendant's motion to compel and request for sanctions filed on April 23rd, 2024. Hereinafter referred to as the response. Lemoyne, Bragg case or Letitia James case or both? Yes. Say that 2 times fast. Yeah. Okay, so belated disclosure of Todd Click letter and evidence. Number 1, in paragraph 15 of its response, the state of Indiana pled to this court that, quote, the state of Indiana did not delay in turning over evidence from Todd Click, unquote. This assertion is false. Number 2, the defense previously provided to this court exhibits 1 through 3, its memorandum in support of the accused's motion for Frank's hearing. This is the defense. The defense previously provided to this court exhibits 1 through 3 in the Frank's memo filed on September 18th, hereinafter Frank's 1. Exhibit 1 is a copy of the envelope containing the Todd Click letter and information, which is stamped received May 1st, 2023, Carroll County Prosecutor, unquote. The prosecution did not disclose the letter to Mr. Allen's counsel until approximately September 8th, 2023, which is 4 months and 4 days after the prosecution's receipt. Number 3, the letter and document sent by Todd Click clearly show that he, Click, and 2 other law enforcement officers, Greg Ferenczi of the Terre Haute Police Department and assigned to the FBI Joint Terrorism Task Force, and Kevin Murphy of the Indiana State Police, believed that third-party suspects were involved in the murders of the victims, and that the evidence against Richard Allen was not nearly as compelling as the evidence they had unearthed on certain third-party suspects. Of course, if Nikki has his way with his motion that we just read, none of this would be admissible. Hote, thank you. Tara Hote. Thank you, Rex. I really wasn't sure. It's the capital of Indiana, isn't it? Okay, number 4. Because of Click's concern that the prosecution was neglecting the evidence gathered by law enforcement officers Todd Click, Greg Ferenczi, and Kevin Murphy, he, Click, hired a lawyer to help draft a letter to Carroll County Prosecutor Nicholas McClellan to alert him that he, Click, believed that third-party suspects were involved in the murders. So see, Click really is giving the benefit of the doubt. All right. He thinks that Nick just doesn't know, right? That the task force, with Liggett and Holman and Carter and Mullins, that they all brushed it under the rug. And they gave the wrong information to Nick, and Nick doesn't know about it. And that if Nick knows about it, he's going to do the right thing, which would be maybe back off on the charge, maybe not dismiss it, but at least look at the information and then make a decision. Oh my gosh, yes, this wasn't presented to me. I didn't know about it. This is much stronger than what they've given me about Richard Allen, and rethink the charges, right? That he would think logically. He would think according to the law. He would think about justice for Abby and Libby, right? Because that's what this comes down to. If Richard Allen's the killer, then great. Lock him up and throw away the key. But if he's not, where's the justice for them? So it's where Ferenczi was killed. Yeah, outside, I think it was an FBI office. Okay. Yeah, poor Click. Number 5, it is hard to imagine a more exculpatory type of letter than one in which an investigator is courageous enough to detail that he and 2 other investigators believe the prosecution may have accused the wrong man. Click's fearlessness also involved going to the lengths of hiring a lawyer to proactively steer the prosecution toward the actual killers. That's a bold statement. And away from possible injustice against an innocent man. I think, though, that they're saying that's why he wrote the letter, because that's what Click believes, right? And do you think Nick wants any of this going before the jury? No. These guys worked with the Joint Task Force, which had been investigating the Vinlanders for years. And I think they know about Odinist. Absolutely. If there's anybody that is an expert on Odinist activity, in particular with the Vinlanders, it would be these guys. Number 6, additionally, through his letter, Click wanted to ensure that the prosecution had received all the evidence that Click possessed of the other third-party suspects that should be turned over to the defense. The prosecution failed to retrieve the evidence from Click until approximately August 30th. So he wrote the letter in May. I mean, it was stamped received May 1st, 2023. They did not try to retrieve the evidence from Click until August 30th, which is only 1 week before they, gave some more discovery to Baldwin and Rosie, because remember they mentioned the 8th, right? So 1 week before they go and they get this evidence. The prosecution only retrieved the evidence after it realized that the defense had learned of the third-party suspects through other documents. So again, they thought that it was under the rug, but you know what? There was a little bit that was there, and Baldwin and Rosie found it. And then they knew that they'd get busted for not giving the evidence. So they had to give it to them. 7, the evidence that the prosecution failed to retrieve for 4 months, failed to retrieve from Click, includes the following: multiple interviews of Elvis Fields, interviews of Rod Abrams, interviews of Johnny Messer, additional interviews. Rex says, I thought about something the other day, Maven. Alan said he was looking at his stock ticker. Yes. And everyone thinks, who looks at a stock ticker? Like, yeah, right. But February 13th of 2017, okay, you're right. That was all YouTube would let you write. So now you're writing some more. What happened on February 13th? Something happened in the whole week was record-breaking week for stocks. And yeah, why shouldn't he be looking? You know, if you have stocks, why wouldn't you be checking it anyway? I mean, it's easy enough. Okay, back then, it would have been easy enough for sure to check his app or whatever, or check his mobile data on his phone. You know, whether he's using a browser and like going through Chrome or something, or whether he's using an actual app, it's gonna, you know, the mobile data it's all there, you know. The prosecution had never disclosed any of these documents to Mr. Allen's counsel until September 8th, right? Just mentioned that 1 week. There were many exculpatory statements made by witnesses discovered in these interviews. Yeah, it's a good thought. It's a good thought. Yeah, I can't believe that some people would be poo-pooing. Oh, why would some hick from Delphi be looking at stocks? Right? I guess that's their mindset. Come on, give me a break. Lots of people have money market accounts, IRAs, you know, individual retirement accounts, things like that. They want to know what's happening with the stocks and what's happening to their money. You don't have to be some kind of bigwig in order to invest in stocks. I've had stocks before. You just a couple $100, you can buy some stocks in a money market account. You know. Okay. It was Bitcoin. I stay away from that, man. Odinist Minnesota Vikings fans. Oh, Andy. Moving on to number 9. There were many exculpatory statements made by witnesses discovered in these interviews, including a key piece of evidence that connected Elvis Fields, Rod Abrams, and Ned Smith, all of whom resided in or near Rushville. So connecting those three to Brad Holder in the Logansport, Delphi area. I'm wondering, did they find spit on the girls? Was it collected? Was it tested for DNA? And then was Elvis Fields tested to see if it matched? I mean, I could totally see these guys just wiping it off the body and not even collecting it at this point. I wouldn't have thought that a year ago. But now at this point, I wouldn't put it past them. Uh-oh, Rex is no longer friends with Andy after his Minnesota Vikings comment. Oh, sports people get, you know, they love their teams. It's a question, not a statement. Oh, we can be friends again. Good. I want things to be nice and friendly in my chat. So number 10, This key piece of evidence, as well as other evidence, was not known by the defense until, now see, this key piece of evidence. So there were many exculpatory statements, yes, in the interviews, including a key piece of evidence. That's got to be the spit, because nothing else is actual spit, unless you got fingerprints on the branches that were above Abby's head, which I don't think so. You guys are having fun. Okay, this key piece of evidence, as well as other evidence, was not known by the defense until the state of Indiana provided it to the defense on September 8, 2023, nearly 9 months later than required by rule, and over 4 months after the prosecution learned of the existence of this evidence possessed by Click. So fair enough. He's giving the prosecution a little bit, excuse me, a little bit benefit of the doubt that Nick only knows what the investigators give to him. And if they didn't give it to him, then how can he give it to the defense, right? So if he did know about it, he's guilty of 9 months. If he didn't know about it, he's still guilty, but only of 4 months. All right. Number 11, because of this late discovery, the defense was denied the ability to conduct its investigation in a more efficient manner and more quickly focus its defense on third-party suspects, thereby putting the defense behind where it would have been in terms of preparation than if the state had complied with the rules. Blue jacket may be that he tried to give to his sister. So yeah, and Nick, in what we read in the beginning, it doesn't want anything to do with if you talk about a third party suspect, then you're confusing the issues and prejudicing the jury or confusing the jury, whatever it said. Right. But a third party defense is a very normal defense tactic or defense like way of, a thing that the defense does. Exactly. He can't know what he doesn't know. Right. So I think they're being fair. I think they're being fair with that. Still guilty. Either guilty of 9 months or guilty of 4 months. On April 29th, 2024, the prosecution filed a motion requesting this court to limit or deny. No, so April 29th. That was like yesterday, right? He's talking about yesterday. He's talking about what we read in the beginning. The prosecution filed a motion requesting this court to limit or deny Mr. Allen the ability to present evidence of third party suspects to a jury. See, Chalet, it's not only you that it happens to. Chalet gets freaked out when she makes one comment and then she makes a couple more comments, but I've only read the first comment and I start saying exactly what she's already said in the second and third comments, right? Well, the same thing happened here. I was just saying that they're removing the ability. I mean, they say it nicer, I guess. They're removing the ability to present evidence of a third-party suspects to a jury, which is a normal thing to do. I mean, if it's real, I mean, you can't just make it up, right? Then that would be egregious of the defense to just pick a name out of a hat and say that there's a third-party suspect. That's not right. But that's not what they're doing. All of this came from the investigation itself. Maybe Click and them collected the blue jacket. Maybe like they collected the phone and nobody's talked about it. So Elvis Fields allegedly tried to give a blue jacket to MJ, his sister, according to her, when he made his confessions to her on February 14th, the day after the murders. Yeah. And did he go pick that up the same way he went and picked up the phone because Tony Liggett and the task force didn't want to bother because they want those things to disappear? And then you also have a problem with chain of custody, possibly. But I think Elvis Fields is too skinny. Unless, it was Ron Logan's or, I think Patrick Westfall's too tall. I'm not sure how tall Brad Holder is. So maybe, but Brad Holder look, okay, when you've got Bridge Guy, he's looking down, and you only see so much of the face. To me, in my eyes, it's equally Richard Allen or Brad Holder at the time. If you see pictures of them from February 2017, they both equally look like Bridge Guy as far as the face. However, I know I've followed somebody that is actually done like the computer forensics of measuring the shadows and all of that kind of stuff. And the person that's Bridge Guy is taller than Richard Allen. So Richard Allen can't be Bridge Guy. Possibly. It's not part of court yet or anything. Not that this guy would be part of court, but there's got to be expert. If this guy can do it, there's experts that are doing it, right? He doesn't even have to be Bridge Guy for Bridge Guy to say, here, take this stuff with you. You live 2 hours away. They won't be looking there. Exactly. So let's say it was Brad Holder's jacket or Ron Logan's. Because I think, when I look at Ron Logan compared to Bridge Guy, he looks like it, and he kind of walks with a bit of confidence, even though you got to be looking at the trestle because there's gaps between the railroad ties, so you got to be looking down so that you step on the wood. And also there's rotten pieces of wood, so you got to make sure you're not going to step on someplace rotten as well. But if that was his property right there next to the trestle, how many times does he go across that trestle? It would be very familiar to him. But he's not around anymore for us to check if he was Bridge Guy or not. I don't know. All right. So that was number 12. Number 13. Mr. Allen's counsel believes that this further supports its contention that the prosecution was attempting to conceal evidence of third-party suspects throughout this case, including the identity of a Purdue professor in a September 6, 2023 email, as well as the click material detailed herein. Okay. Number 14, Mr. Allen requests that the prosecution be sanctioned for not turning this exculpatory evidence over to the defense, and then for falsely claiming to this court that the prosecution, quote, did not delay in turning over evidence from Todd Click, unquote. So number one, that they didn't turn it over, and number two, for lying about it. Now we get into the email concerning the Purdue professor Jeffrey Turco. The video is so misleading. It isn't a video. It is a live photo that is compromised of multiple frames to make a video, in which there are micro gaps between the frames, giving the illusion of a limp. Yes, and also I heard that it was adjusted, you've got a man walking and you've got the trestle, and and it's all bouncing and moving away. And so like you choose something to stabilize on, right? So you could stabilize the trestle or you could stabilize the man. And I think, if I remember correctly, when they stabilized the man, then therefore you don't actually get the movement, his movements, is because he's been stabilized. And so somebody else like stabilized on the trestle and then showed him walking. And it looks a lot different. Yeah, I don't think he had a limp. I think he was watching his step on the trestle. All right. Email number 15. In paragraph 16 of his response, the prosecutor asserts, quote, the state of Indiana did not mislead or lie to the defense in an email, unquote. This short assertion, consisting of just 15 words, is false. I'm going to open up my security camera app and see if I see anything outside. What? Any editing nullifies? Well, yeah. Yeah. So whichever way things were like done up. Yeah. There you go. Okay. My motorcycle's still parked there. I don't see anybody inside. There's some banging. So I've got like, my yard has like a metal gate kind of thing, a metal fence all the way around it. So there's nobody inside the fence that I can see on my security camera. And the dogs have stopped barking, so. Looks good. Gotta check that when the dogs are barking that much. All right, but they're done barking. 16. Mr. Allen's counsel provided the prosecution's September 6, 2023 email to the court as an exhibit to the defense reply to prosecution's response to Third Frank's memorandum on April 8th, 2024. So just 3 weeks ago. This reply also provided the context of why this email was false and misleading concerning the identity of the Purdue professor. Furthermore, in his September 6, 2023 email, the prosecutor failed to disclose to the defense that at that time, September 6, 2023, the prosecutor already had in its possession the Purdue report and had possession of that for at over 2 weeks at the time the prosecutor sent the email. The state of Indiana failed to turn over to the defense that exculpatory document until October 4th, 2023, and only upon request of the defense. So these emails that they're talking about is when, I believe, when the defense was asking, hey, you know what? There's mention of some kind of report that was done about the runes, about whether or not the sticks, you I think it was Liggett or Holman said the sticks we presented, I guess crime scene photos to, or at least we asked for the expert opinion of the sticks, and the expert came back and said they're not runes, right? So that was included in the discovery. And then the defense goes, runes? Wait, you had an expert? You consulted an expert? Well, where's the report? You're telling us that they reported that they weren't runes. So where's the report? I want to read it for ourselves. And so they requested that, and then, but through email communication, and then Nick is saying, oh, we don't know where that was or who was the professor. We don't have any report. We don't even remember who it was, which was totally bogus, because then they immediately went and contacted him and whatever. So I think those are the emails that they're replying to, that he's referring to, is that conversation the report. Number 17. Apparently, the prosecution believes that with this court, it can simply make an assertion without facts, arguments, or supportive documentation, and that will be enough for the court to ignore the defense's request that the prosecutor be sanctioned for false and misleading information to the defense. Ooh, yo mama, your grandma, wasn't there a bunch of stuff about grandma? Your grandma wears combat boots? I mean, it just reminds me of that playground insult kind of stuff, you know? What report? Where's the BAU report? You know, but behavioral analyst unit report. You know, where's the report? Where's the report? What report? There's no report, you know? I mean, I love that. Apparently, the prosecution believes that, comma, with this court, with Francis C. Gull, comma, it can simply make an assertion without facts, arguments, or supportive documentation. So the assertion is, yeah, we checked that out. The expert said it wasn't runes. That's the assertion. But there's no facts, no arguments, no supportive documentation to back up that there was an expert that said it wasn't runes, right? And that will be enough for Francis C. Gull to ignore the defense's request that the prosecutor be sanctioned for providing false and misleading information to the defense. 18, the defense is requesting this court to order the prosecutor to explain why he provided false information and misled the defense, and also to be sanctioned for doing so. We'll see what Francis C. Gull does. Outstanding discovery. 19. The defense rejects the prosecution's assertion in paragraph 7 of its response that all the, quote, all the information minus the SOPs, standard operating procedures, and the chain of custody documents was already in possession of the defense, unquote. 20, on Friday, April 26th. Yeah, in your face, sucker. 20, on Friday, April 26, 2024, last Friday, less than a week ago. Today's Wednesday. Last Friday, April 26, the prosecution turned over a multitude of documents. Oh, I did not know this, that they actually gave them some things last Friday, including an exculpatory piece of evidence concerning phone pings that was contained in a report written by Steve Mullins, their little poster boy of the Indiana police. The Delphi Police Department. See, I did it again. Steve Mullins of the Delphi Police Department on August 23rd, 2017. So February, March, April, May, June, July, August, 6 months. What could this be? Including an exculpatory piece of evidence concerning phone pings. Whose phone pings? Oh. Is he going to go into the Libby's phone pings here? I mean, I skimmed through so many different. I told you I downloaded like 5 or 6 friggin' documents, PDFs, right? And so this might be Libby German's phone pings, contained in a report written by Steve Mullins on August 20, 6 months after the murders. Rex says, quote, "We have given the defense all the discovery well before trial," unquote. It's like what, 14 days? Exactly. Okay, so number 21, Mr. Allen's counsel previously asked multiple times for the prosecution to turn over narrative reports related to phone activity, such as geofencing and pings. And the state of Indiana has continually told the defense that no such reports exist. There's no reports. Oh, so wait a minute. So if no such reports exist, that means that you didn't investigate? You've got the murder of 2 young girls that you say that you're going to find justice for them. Today is the day. And you have no reports because you didn't investigate them? You didn't investigate geofencing and pings? Like Forensics 101? That's what you want us to believe? In your face, sucker, as Rex just said. What report? What report? Rex says. Okay. So 22, the exculpatory report the defense received on Friday, April 26, just last Friday, 17 days before trial begins, provides evidence that the victims were not at the crime scene on February 13th, 2017. Boom. There's evidence that the victims were not at the crime scene on February 13th. I mean, for me, that's not a surprise, but it's great that they have evidence of it because I've suspected that. 23, the prosecution claims that it has turned over all the evidence and asserts in paragraph 5 that it has, quote, has no idea why the defense cannot locate the documents. Maybe it has something to do with the labeling that Rick doesn't want mentioned during trial. And that in order to locate the items to appease the defense, the state had to, quote, dive into 26 terabytes of information, often searching several files before the documents can be found, unquote. Oh, you mean you didn't do a good job of labeling? Rick says, I want to go through all of the state's filings and see how many different what reports there are and tally them up. I welcome you to do that job because I'm not going to. But when you get it, let me know. We'll bring you up on panel and we'll do a live stream about it. And I'm not sure do you actually post videos, Rex? I don't know. I have to check. I don't want to. Let's keep going here. I'll have to check and just let me know. Do you actually do videos? Because I'd love to watch your videos. I have to go check your channel. 24. The defense posits, right? The defense posits this question. If it is complicated and time-consuming for the prosecution to dive into 26 terabytes of information and requires searching through several files before just a few documents or pieces of evidence can be found, and bold, underline, and this is the prosecution's evidence, then how can the prosecution expect the defense to locate the items it seeks without assistance from the prosecution? The defense did not organize the discovery. The prosecution organized the discovery during the defense's first tenure on the case, and then reorganized and formatted it for the defense's second tenure on the case. Ooh. So I got 26 terabytes. I know where to find this is labeled this folder's here, this folder's there. Then they get it back and everything's mixed up. Tell me that's not on purpose. Somebody had to reorganize it. Interesting. Oh, Lemoyne has to go. Okay, you have garden stuff to get done. Yeah, before it gets too hot. We're having such a heat wave here. I don't know if you can see how it's like I'm sweating. Oh, it's a heat wave. It's a major heat wave. It's like triple digits. Yeah, so peace to Lemoyne. Okay. Reformatted it. Alrighty. And about this formatting and labeling, can I just say did they just throw everything together after 6 years? I mean, when you go to the police academy, do they teach you how to write reports and how to file those reports so that in your as your investigation is going from day 1, then day 2, we got new interviews. We're putting them in this file. Day 3, we collected this evidence. We got a report in, we've got the autopsy report, and it goes here, it goes here, it goes here. Day 4, all right, we got this folder. Let's add this one here. Let's put this in the interview folder. Let's put this in the evidence folder. Let's put and you keep adding, and it's like, oh, well, you know what? We don't have a folder for this. Let's make a new folder. And in the folder for interviews, you've got Brad Holder, you've got Richard Allen, you've got Kevin Klein, Kelsey German, or, oh, what report? What interview? Yeah, the sister that dropped them off. Like, wouldn't she be interviewed? Kind of like the last person to see them alive. I mean, although there could have been witnesses on the trail, but like the last solid person to see them alive, dropping them off out of their car. All right. Number 25. Okay. Rex says they intentionally threw everything together along with stuff that doesn't belong. Yeah, just to make it hard to find everything. It's ridiculous. It's ridiculous. So basically their excuse, the prosecution's excuse, is that they don't know how to do labeling. So they're like kind of incompetent. That's what they want. That's what they want us to believe. That's what they're telling us. Well, we got 26 terabytes of stuff and it took us all this time. Well, let me get the quote. I'll get the quote. So the prosecution says, quote, has no idea why the defense cannot locate the documents, and that in order to locate the documents, locate the items to appease the defense, the state had to, quote, dive into 26 terabytes of information, often searching several files before the documents can be found. So you compiled 26 terabytes of information in an unorganized way, is what you're saying. That you were incompetent in your filing or labeling, as Nick mentioned in his motion in limine. E.g., video of dead guy on a bed. Where's that? Video of dead guy on a bed. Who's a dead guy on a bed? Are you just talking about cases in general, or are you talking about this case? Because I don't know anything about that. All right, we're on 25. Richard Allen and his lawyers have only reached out to the prosecution after they had spent several hours searching for documents throughout the state of Indiana's. Well, listen to this. Yo, mama. Convoluted, disorganized, and often untimely discovery dumps. Ooh. On this case, a video of a dead guy on a bed. I have no idea what you're talking about. So that's yeah, let me know. Let us know, what is that? Wow. Okay, 26. Oh, are you saying that they included a video of a dead guy on a bed in this 26 terabytes, which is this case, but it had nothing to do with this case, so it was just extra stuff added to make it harder to find things? Is that what you're saying? Okay, we're almost to the end here. It was in the defense's motion to compel and for sanctions. Which I didn't go through all of that. I have them downloaded, but I haven't like done a video on it. All right. So that's why I haven't seen it yet. 26. With collective experience of over 70 years, Mr. Allen's attorneys have never experienced a situation where the prosecution has created such significant barriers to locating evidence while also misleading the defense concerning the existence of evidence. Wherefore, yeah, that's what you're saying. Okay. Your mama and your daddy and your baby sister too, Chalet says. I can just imagine that's Gladys or something. All right. Wherefore, Richard Allen, by counsel, files his reply to the state of Indiana's response and respectfully requests the court, 1, sanction the prosecution as previously requested in its motion to compel and motion for sanctions. Okay, so when the defense did their original motion to compel that the prosecution replied to, they're saying sanction them according to that original motion. Number 2, sanction the prosecution for providing false information in its response. Okay. Number 3, as a result of said sanctions, to order the prosecution to provide an itemized list of all documents, videos, recordings, and other evidence provided to Mr. Allen's attorneys and the location of each item. Oh, let me reread that a different way. Provide an itemized list of everything in 26 terabytes. Forget about working on your trial. You got a trial in 2 weeks, bud, but you got to have somebody make an itemized list. Oh my goodness. A lot of just. Number 4, order the prosecution to explain misleading and false representation. September 6, 2023 email. So that was the Purdue thing. And for all other just and proper relief in the premises. It's respectfully submitted, Baldwin, Rosie, and Jennifer Auger. Stink eye on all that. Yeah. Might as well peel potatoes. Oh my goodness. Oh my goodness. Okay. Done. I'm closing it there. I'm closing it. I'm removing it. Oh my goodness. Where's Libby and Abby in all of this? You know, I kind of have a saying. Okay, I moved to Cambodia 17 years ago from the US. Most of you, I think, know that. And one of the things in developing countries that's big is rule of law. So the US and the Western nations are always pushing the developing countries to have rule of law so that there's no corruption in the courts. That's a fake cough. But I will take a drink of water. Rule of law, because they're trying to sell rule of law as justice. That's what people want. They don't want corruption. They want justice. However, what they don't realize is that rule of law is what you're seeing right here in the Delphi case. It's the technicalities. It's the rules of court, the rules of trial. Rule 401 is Nick McClellan was talking about. You know, oh, this rule. And if you're poor, the more rule of law the less justice there is, because you're not getting a fancy I mean, Richard Allen, got really lucky with these guys, because they've discussed, they did their digging and they found something, and they I think they believe he's innocent. I don't know if he's innocent. I'm not privy to all the information they have, so I don't know. But they believe he's innocent, and I think that's why they're going to bat for him as hard as they are. And so yeah, the rule of law. Then the rich people can have fancy lawyers that can twist everything, get things inadmissible, everything you're seeing here is rule of law. And that's why there's less justice with rule of law. What they really want is justice. They want a court system that, everyone has access to. Let's see. Chalet says, make tater salad with those peeled potatoes. Rex says, you definitely have to read about the dead guy. Like, what? Okay, but I can't do that in this one. This one's been long enough. The rule of law sucks. Exactly. There's no justice without truth. There you go, Rex. Chalet says, well, yes, that's where words mean everything. Exactly. Rex says, rule of law is moot without truth. Thank you very much. And another case that comes to mind is O.J. Simpson, because there was so much evidence that the prosecution had that Judge Ito was like, oh, okay, yeah, inadmissible. The jury can't hear this. The jury can't hear that, which is what I don't know. I'm thinking that I'm thinking that Judge Ito is like the role model for Judge Gull. I really do. I think she idolizes Judge Ito, because if she doesn't idolize him, she's definitely channeling Judge Ito, because she's doing exactly the same thing. Rule of law set him free. Set who free? Well, if the rule of law has truth, like I said, but truth can be inadmissible. And that was the problem. There was Marcia, who was the lead prosecutor in the OJ case. And then there was another guy that was second prosecutor. And he wrote a book. And I read his book that he wrote, where he outlined everything that they had that Judge Ito didn't let in. I was like, whoa. Yeah. And I see a repeat. Only instead of it being the defense that's acquitting, that's getting OJ acquitted, it's the prosecution that's getting Richard Allen convicted. But I see the same tactics, only by the prosecution this time. But the judge is acting the same way. She's just doing whatever she wants to do. And there's a certain amount. Okay. The judges need to be able to have discretion. All right. Yes. Judges should have discretion, but it needs to be within, there's got to be some boundaries on that discretion. And Judge Gull is acting like she's got no boundaries, and she can do that. You know what it reminds me of? It reminds me of my ex-husband. Where I was like, this is my house. I can do whatever I want in my house. Like that. I feel like that. This is my court, and I can do whatever I want in my court. I get that feeling from her. We'll just have to see. We'll have to see what she does. She hasn't ruled on that hearing yet, right? I mean, the hearing that they had in court, where the prosecutor wanted sanctions or whatever on the prosecution was attacking the defense, saying they need the contempt. It was a contempt hearing. That's what it was. She hasn't ruled on the contempt hearing, has she? I haven't heard anything. The court's idea, Rex says, the court's idea is we only care about the truth if you can find a rule of law that will allow it to be brought up. There you go, Rex. Yep. And Chalet says, give some people a little power. That's right. Give them just a little inch and they take a mile. You know, whoo, I like this power. I like this feeling of power. Yeah, buddy. Rex says, people don't understand. We have the power and we let this happen. You're right. And I think that's at least talking about it is a step. Talking about it isn't going to change it in and of itself. But if we talk about it and if we stop talking about it, it's done. It's done. They win. They, meaning anybody that wants to abuse the system, not just this case, right? If we stop talking about it, then absolutely nothing is going to happen. But if I mean, like I'm over here in Cambodia, what am I going to do? You know, well, I can talk about it, you know, and then maybe that's a piece of the puzzle. What is it? They talk about the butterfly wings down in Brazil or in the Amazon or something, and then it ends up making a hurricane. You know, I mean, it could be part of something going in motion to a change happening. But I mean, who knows? They might find him guilty because, you know, we could have an OJ situation, as I just said. So Gull doesn't let anything be admissible. Everything that Nick McClelland is just saying, that like you are not allowed to have a defense, present a defense for Richard Allen, because if you say anything that undermines the fact that he's guilty or causes reasonable doubt, you're in contempt, basically, right? So, and then that goes to appeal, and then whatever way the appeal goes, the other one is going to appeal it again, and it'll end up going to the Supreme Court, like not just the state Supreme Court, but like the national Supreme Court. Rex says the Constitution was made so that the people can prevent the government from doing this. Yeah. So that the government power is under control from doing this very thing. I know. And I think people just get caught up in making a living, you know, just getting by, just living paycheck to paycheck, you know, and they don't have time to think about things outside of their life. You know, I think that's for the majority. I think that's what happens. I think that's why you can actually find juries that don't have a clue what's going on, because they really don't listen to anything else. You know, if it wasn't me, oh, by the way, Mumsy had something to do, so that's why she's not in the chat today. But my mom is someone who, unless the nightly news, you know, the mainstream media mentions a case, that she's not going to know anything about what's going on anywhere else. She doesn't care because it's not her life. It doesn't affect her life. She thinks it doesn't affect her life. But as we know, you let courts get away with this. You know, maybe she goes on a road trip or a vacation, and she ends up in Indiana and breaks down, and then she gets her car fixed, and they keep going. But where she broke down and got her car fixed, a murder happened. And now they got, oh, well, you were there at the scene of the crime. It happened in that mechanic shop, you know, where the mechanic got murdered. And now it affects her. People need to trust their leaders. People need to have leaders that run for office, you know, that are good choices for us to vote for. And then, Queens, that fishing tournament. Oh, good for them. Queen Queen and CFM Rocks is doing and that's like, there's a big charity element to that fishing tournament. I think that's good for them. And she says, keep people working all the time and no time to think. Exactly. Andy says, miss you, Christine. Yeah, she'll watch the replay. So she knows about this stuff because it's me. So, and I'm on to her about the watch hours. Mumsy, I need the watch hours. Make sure you watch it. And my kudos to my stepdad as well, because and sometimes he'll write a comment because he'll watch a replay. He never joins the live, but he'll watch the replay, and then he'll leave a little comment, and I give it a little heart. So okay, thank you for that. I misread something Shalay said. She said, no, I said people trusted their leaders blindly. Oh, yeah, that's a problem if you just blindly trust leaders, for sure. Rex says the leaders work for the people. We give the control and bow down to the government's power because we are sheep. We like being told what to do. I think that's true for a lot of people. I think most people, it's like, just give me my paycheck. And they don't even like look at all the taxes that are being taken out or how much they just know this is my net pay. The gross pay is irrelevant because I don't see it, right? It's the net pay is what I got to spend and what I got to work with for my budget. So, I mean, even to that level, people are blind to what's going on. They take advantage because they can, absolutely. And they think they think they like being told what to do. Well, the people being told what to do think they like being told what to. Yeah, it's true, because a lot of times then it absolves you of any responsibility, right? If someone else made the choice, then it wasn't me that made the choice. So, it's not my fault, right? Until they're told, okay, they think they like being told what to do until one day they're told everything that they can do or can't do. And Rex says 100%. It reminds me here in since I'm in Cambodia, there's a casino. There's one casino in Phnom Penh, and I don't know, years ago I went there, and okay, so they've got 21, they've got poker, they've got slot machines, and they've got this game called Mahjong, Mahjong, right? So I'm standing by the table, and it's got these like tiles, kind of like when you play dominoes, so there's like, but instead of dots for dominoes, it's like different symbols for different things or whatever. I don't know how to play it, but I'm like watching the people play it. And it like dawned on me that there's absolutely no thinking. Like when you play 21 or you play poker, you got to choose. You got to know when to hold them and know when to fold them. And 21 is like hit me or not hit me. You got some choice, right? There's like absolutely no choice in this Mahjong thing. It's like whatever tiles that you're given, that's it. And I'm like, well, what's the fun of that? I mean, and then I asked, and somebody said, because if you win, it's luck. If you lose, it's luck. You didn't lose. It was luck. So it absolves you of that gambling. Like you didn't lose gambling. We might say fate. It was fate that it happened. I lost because it was fate. You have absolutely no thinking at all. You just sit there at the table and keep putting money down. What? I don't know. Well, even 21 in poker, you're going to lose more than you're going to win. We are Rex. Well, let's see. Wait. Shalay says, if you choose not to decide, you still have made a choice. Yes. And Rush. Oh, like the shooting on the Rush set. Rex says, we are taxed on our paycheck, taxed on our property and goods, pay taxes at the end of the year. We aren't free and we own nothing. We just pay rent and our government is our landlord. Rex says, don't pay taxes and I bet you lose your freedom and your home. Absolutely. Oh, the song. Oh, Rush. Ah, yeah. The metal band, Rush. Got it. Where did Andy go? He's just probably listening or he's driving. Oh, there he is. Yeah, Rush the band. Yeah, I remember. Aren't they the ones with like kind of like a pentagram or an anarchy kind of sign or something? If I recall, I remember the t-shirts. I was into Striper. They're a Canadian band. I did not know that. I did not know that. All right. Well, we've covered our topic, and we've done a little bit of rambling, and I think it's been a good show. But yeah, it's about time. So your brother was totally into Rush. Getty 2012, 2112, 2112, 2112. Say it a lot of different ways. I don't know. I wasn't into Rush. Okay. So you guys know that that love transcends time and space. Isn't that cool? It's true. So whenever and wherever you are watching this, I love you. So that's it for tonight. Yeah. Did you spell it wrong? Oh, it doesn't matter. I don't know the band members of Rush. But you're forever like here that people know. Rock and Roll Hall of Fame. Alrighty, Andy. Yeah, that's you. It's all in your head. You know it all. I mean, in a good way. I bow to you when it comes to music. All right. Love you too. And I look forward to seeing you guys again. We're going to stick with Gen X tomorrow. But if there's no new filings, then we'll go over the defense's motion and the response that they were talking about today. Rock on, everybody. Oh, and there's the fourth Frank's hearing too, because that's like long. All three of them are long. So peace be with you guys. Yes, I see that. Rock on, everybody. So tomorrow, Gen X will have fun. We'll leave all this away and have fun. All right. See you tomorrow. Same bat time, same bat channel.